Well, the risk is,
You've determined that there's enough of a conflict to suggest that Mr. Beam should recuse himself.
I've
And
opined that there's an appearance of conflict, he should recuse, he's recused, he's gone, that's done.
we have,
Listen, I don't care if you didn't have the opportunity to question him, it's irrelevant.
I know you don't care.
He's gone, okay? So proceeding at your own risk, I think you know what that means, but just because
Why don't you tell me what it means?
what it means is, if the board were to grant the application and the objectors or anyone filed an appeal, I'm gonna take the position in the litigation, we're gonna do whatever, we're gonna abide by the ruling of the court. You will defend the fact that we went on after Mr. Beam recused himself, but he sat with the board for 4 hearings.
So-
That is proceeding at your own risk.
So I have to defend your position to tell Mr. Beam to recuse himself in the
No,
board.
you have to
And the
defend,
board's decision to
no, you
proceed.
have to assume that he correctly recused himself, but that there was no taint because,
How do I assume such a thing?
listen,
How
I
do
don't
I
know
do
what to
that?
tell you.
How do I do that when Mr. Beam isn't here to answer any questions or actually put a statement on the record?
Okay, Mr. Beam, under the law, does not have to answer any questions.
Okay? And then how am I supposed to make an educated judgment, take a position on behalf of an applicant who spent hundreds of thousands of dollars to this point on this proceeding? And we have 2 objector attorneys who have stated their position that they believe that there's a problem, and now you're asking me to waive it to defend
No,
that.
I'm not asking you to waive it. I'm asking you, what do you want to do about it? And if the answer is I want to question Mr. Beam, that's not happening. Okay, and you can go to court, you can, under the prerogative writ rule, you can ask for an interlocutory appeal to question him, and the judge is gonna say that you don't get the
Well,
question.
you don't know what the judge is gonna say.
I actually can predict what the judge is gonna say.
It's impressive.
If Mr. Beam did not want to recuse himself, then the judge would probably allow you to ask him questions to find out if there was an actual conflict. But because he hasn't recused because of an actual conflict, he's recused because of an appearance of conflict, I don't think the judge is gonna let you ask him any questions either, because it's a done deal. And by the way, for the record, I've sworn in Mr. Barsany, the mayor, he's now reclaimed his class 1 seat. Can I please have his oath of office before the meeting started? Because Mr. Beam has recused and the mayor has no longer designated Mr. Beam as the class 1. The mayor has taken the class 1 himself. And as of this evening, at about 7:20, I swore him in. So he is now a sitting member of the planning board, and Mr. Beam is no longer the designee on the planning board. What do you want to do? Do you want to go on tonight or not?
There's more to the story, Mr. Drill, as you know, right? I can't take a position that puts the applicant in any further prejudice than he's already been put in to this point in time. It is unclear whether or not there was more to this appearance of impropriety, right? We, neither of us know that, or I don't know that. You may, I do not. Some of the members of the objector may or may not. In fact, if Mr. Gruenberg is counsel to Bloomsbury, he may know more information about it than I. In which case, if it comes out at a later point in time and it does determine that the proceedings have been tainted, it's not for me to know until we proceed down this path at our own risk. And that's not something that we believe is in their best interest. However, also starting over would put a significant prejudice on the applicant as well. Now, it's not clear why Mr. Beam did never disclose this conflict of interest or appearance of interest, when we all know that within the first 5 minutes of the first hearing on March 13th, you introduced Mr. Gruenberg's associate as representing the township of Bloomsbury. Mr. Beam was present in the room, and he was aware, because they appeared at every hearing and they participated in all of the hearings, that his employer, as you stated, and I'm not even sure if it is his employer, but his employer was participating in this case. Mr. Beam took it upon himself to remain silent at the prejudice of the applicant. Now, 6 months down the road, this has become an issue where we have to potentially start over. The applicant, as I'm sure you know, has spent hundreds and hundreds of thousands of dollars from the start of this application, paying both professional fees and paying the professional fees of the board as well as the cost of having the court reporters. The cost of this exorbitant, what I believe is an illegal application fee that we paid under protest, and which Mr. Beam also presided over in his position as deputy mayor when we challenged the application of that fee. All of these things have significantly prejudiced the applicant, and now you're asking the applicant to potentially have to start over in order to prevent any potential taint of this application. The applicant, it's like any other applicant, doesn't just have unlimited funds where we can just go back and spend $500 to $1 million to restart the application to do the same thing twice. There's a contract in place for the sale or for the purchase of the real estate. As you know, I identified them as a contract purchaser. There are additional fees that would have to be spent, and all of the different changes that we've made up to this point were at the direction of this board mostly, and the board's professionals, based on what you claim to potentially be a tainted board or an unlawfully constituted board.
Again, don't put words in my mouth. I didn't say they were tainted. I said to eliminate the challenge that someone could say that the proceeding was tainted. I never said that I thought this proceeding was tainted because Mr. Beam recused himself. I never said that. That's not my opinion.
It was your opinion that you would advise the board.
That to eliminate the issue of taint, yes,
Correct.
not that,
You're gonna eliminate the issue of taint, but you're not saying it's tainted.
that's right, because quite frankly, my legal things, I don't think it's tainted. Okay? But I don't want it on the board. We are where we are. I want you,
Yeah, it's very easy for you to sit there and say you don't want it
correct,
put on the board, and then to put it on the applicant to say you can either do one of the two things.
that's right.
Neither of which are going to be fair to the applicant.
Well, I don't know what else you want me to do. You want me to make the decision for you. I'm not doing that. I'm laying out that, in my opinion, Mr. Beam had an appearance of conflict. I advised Mr. Beam of that. He agreed. He sent me an email on Tuesday, August 5th, saying that it's been brought to my attention that due to my employment in Bloomsbury Borough, that there might be a conflict of interest. So any matter involving the Tinsley application, I will recuse myself from the Greenwich Land Use Board. That's the email he wrote to me. So he's gone, like I said. The mayor has reclaimed his Class 1 seat. I've sworn him in. I'm asking you again. I want to make it clear. In my opinion, Mr. Beam did not give any indication if he was in favor or against the application. He may have asked under 6 questions. I don't think he opined one way or the other where he was going with it. Once this was brought up, he recused himself from it. So in my opinion, I don't think the proceeding is tainted if it goes on, but I am not going to unilaterally tell the board to go one way or the other. It's the applicant, like you said, it's the applicant's money, it's the applicant's application. In my opinion, the board has to hear from you first on what you want to do. If you wanted to restart, I would tell the board, I think you should restart. If you wanted to proceed at your own risk, I would tell the board, let you proceed at your own risk. Now, I would take the board into closed session because maybe they don't agree with me, but that's why I'm asking you that I think whether it's fair or not, or whether it appears fair or not, you and on behalf of the applicant have to tell the board, what do you want to do, knowing where we are now?
Right, and the one thing I agree with you, it is not fair to the applicant. The applicant has to be put in a position where they either proceed knowing that there's 2 objector attorneys who are chomping at the bit to challenge, or to start over if they have.
But I'm glad
to do that.
You're probably glad that you heard that it was my opinion that the proceeding's not tainted.
That was nice of you to say, I suppose.
Well, that's my opinion.
I appreciate it. I appreciate your opinion one way or the other. I'd have to ask for a 5 minutes.
Yeah, that's totally fair. And I think if he's gonna ask for a 5-minute recess, rather than get his answer first, why don't we go into closed session? So I can, give you different scenarios and we'll see what he has to say. Now, the objectors, you wanna say something?
Yeah.
Can you let him come up? Mr. Simon wants to say something. Let's hear what he has to say. Sometimes Simon says very interesting things.
There we go, good. I mean, certainly before,
Identify yourself for the record.
Rob Simon from Herald Law on behalf of Skyline.
Again, that microphone doesn't work.
I understand. It makes me feel better.
Okay.
Okay. So just a few things here, and I was constrained to get up and say something, not to interrupt the proceedings necessarily, but because I am concerned about some of the things that were stated. And I just want to make sure that certain things are clear. First of all, this is not intended to be an adversarial proceeding. And I take great offense at anyone implying, accusing, or let alone stating, as he did tonight, that objector attorneys are quote unquote chomping at the bit. Okay? That's improper, respectfully, as was it improper, respectfully, the way that applicant's attorney spoke to the board attorney. Okay? We need to take it down, not a notch, we need to take it down 4 or 5 notches. Okay? I understand there's a lot of money at stake. Understand that there's issues, legal issues that need to be determined here on all sides. Applicant side, interested party side, board side. But we need to do it with a sense of respect and decorum. And certainly, at least from my side of the aisle, intend to do that. Another comment, before I get actually to the law. I think I heard that it's unfair to the applicant because they essentially, and I'm not putting words, Michael, in your mouth, have to start over from scratch. Let me explain something about interested parties.
He said it's unfair that he be put in a position to either decide to start from scratch or decide to proceed at his own risk. That's what he said was unfair.
The only comment I want to make with regard to that is, it is not as if, and these circumstances certainly come up in a wide variety of ways. But the one thing that I think is a common denominator when they do come up is that there are ways to, when you do start over, and we believe you do have to start over, to start over in a way that is as least prejudicial, certainly, to an applicant, number one. And keep in mind that it's not as if the applicant had 4 nights of hearings and everybody is saying, great, love it, no problem, no questions. And now they have to start over 4 nights of hearings. Keep in mind, there were tons of questions from the board professionals, members of the public, review letters from Mr. Good, from Ms. Lely, that have resulted in changes, modifications, comments from the applicant's professionals during the course of answering questions about making modifications to the plan. And one of the things that is the goal of the public process is to try to make the application better, to improve the application, whether it rises to the level of whether it should be approved or denied is not the issue yet. But at least through the course of the public participation, the board participation, the professionals' participation, modifications are made. Oh, we can move that, we'll change that, we'll consider that, etc. So you respectfully, you can't say with a straight face that we're starting over from scratch. Far from it. The application as represented will certainly be different than what was originally presented for 4 hearings ago. And keep in mind too, in terms of the law, and I could go off in terms of, and Mr. Drill knows it just as well as I do, whether it's the local government ethics law, whether it's municipal land use law, whether it is common law, on the various cases that Mr. Drill is very familiar with, Mr. Lepari is very familiar with. It is the potential for conflict. It is the appearance of conflict. It is not proof of actual conflict. It is not proof of actual dishonesty that commands a public official to disqualify himself or herself from acting on a matter on a matter of public interest.
Just for the record, I based my opinion of an appearance of conflict on the local government ethics law, not on the MLUL.
Okay, but certainly, whether it's local government ethics law, MLUL,
Common
appellate
law,
division
whatever.
decisions,
Right.
Supreme Court decisions, that I certainly would, welcome the opportunity to provide a brief on.
No
It's
need for
pretty
a brief.
clear.
He already
Right.
recused.
Okay, right? So I think that, unfortunately, there is, because of a recusal, that if there is a member of the board who is participating on a matter that the law provides, in our opinion, that any decision that flows from that participation, no matter how limited it may be, renders any decision from by that board a nullity by conflict of interest. That is why when issues are brought to the forefront, as I guess Mr. Grunberg did via his letter about the issue, and it's dealt with promptly, that's exactly what's supposed to happen in these kind of cases. And exactly the timetable that led us to this very moment is exactly what should happen. So as you go into closed session and you think about this and you discuss it, keep in mind that we respectfully believe that local government ethics law is clear, municipal land use law and conflict of interest is clear, common law is clear in terms of what should happen here. And certainly there are ways, and usually what happens is, and I'm saying this whether I'm an applicant's attorney, I'm an objector's attorney, I'm a board attorney, that what happens is that, frankly, the attorneys initially, in my experience, for what it's worth, get together and discuss, well, how can this matter go forward in an appropriate way as a restart, okay, to try to make it as efficient as possible for the board, for the professionals, for the public, okay? And you try to figure out what's the best way to do that under the circumstances. And then you proceed that way, okay? By the applicant taking the position of saying, well, we're just gonna continue, and I don't know what they're gonna
He hasn't
decide.
said that.
I don't know what they're gonna decide.
Correct.
Right. It was an obligation on myself, I believe, by Mr. Grunberg, to lay out right now and not, be
But
sneaky
you're
about
not
it.
allowed to keep anything up your sleeve.
Nothing
The
up the
appellate division
sleeve.
case says that.
It's all right here,
Right.
right? So I just wanted to.
I just want to make, so it's your position that legally you believe that the proceeding is tainted. And if the board were to grant the application, and if you were to appeal, that would be one of your appellate issues, that the proceeding was tainted. That's what you're saying.
Absolutely, and there's law to back that up for sure. That's our opinion.
Mr. Bloomberg, you want to add something just to?
Very brief. I brought the issue to the board's attention immediately upon me discovering it from a member of the public who came to me and said, hey, Mr. Beam's actually employed by the borough as the zoning officer. So that was the intention. I did it immediately, had no idea or inkling of a conflict of interest before that. I just wanted to put that on the record. As soon as I knew, I did the August 5th
And
letter.
again, you're saying a conflict of interest.
In terms of,
You agree with me, it's an appearance of conflict. You're not, your letter actually would say that there's no actual conflict, because you even said in the letter that you have no reason to believe that he couldn't judge the application impartially. So your
Correct.
position is that it's an appearance of conflict, and I am correct on that. Is that correct?
under the particularly under the local government
Okay.
ethics law and under I agree with Mr. Simon, under the municipal land use law and common law, that it is a reason for Mr. Beam to have recused himself due to the appearance of a conflict. Practically, where do we go from here? I agree with Mr. Simon that because of that conflict, there would be a taint. And it's not just whether Mr. Simon agrees that it would raise it as an issue of a taint, or whether I would agree that raise it as an issue of a taint, but there's been several hundred people in the audience in some of these hearings who may also challenge in the future that the proceedings were tainted. It's not just these two attorneys here who are acting for interested parties. The other issue that I raised in my August twelfth correspondence and respectfully is whether the mayor can step in and reclaim his designee status.
Yeah, okay,
For
let's
class
just
one.
dispense with that. I agree that if the mayor had a conflict, right? He could not then designate someone to take his place because it would be his designee. Your letter says an argument can be made that the reverse is true. Make that argument, because I can't imagine an argument being how his designee having a conflict flows uphill to the mayor. I only see it flowing downhill. So how does Mr. Beam's appearance of conflict flow up so that to the mayor that he somehow has an appearance of conflict? Please explain this.
I can explain it to you that if the mayor has already designated that position to be held and has stepped back and designated a person as his representative on the board, and that person ends up having the appearance of a conflict, then I think an argument could be made that it flows back. We'll save it for another day. But anyway,
No. I don't want to save it for another day. You said an argument can be made. Make the argument.
I just did. That
No, you
there's
said an argument
appearance-
can be made. You didn't make the argument.
Well, I'll make it another day is what I'm
No,
saying.
no. Come on, you got up, you wanted to speak.
It's just under the same basis that if the mayor was sitting on the board and had a conflict, then his designee can't step in and say, okay, well, now I'm stepping in position of the mayor. The mayor has divested himself of his position on the board by designating Mr. Beam, the deputy mayor, as his position.
He's
But
been-
now.
He's been
Mr.
undesignated.
Let me finish. Now, Mr. Beam has been determined to have need to recuse himself. That's with respect to the class one position on the board. And you may disagree with
Okay,
me.
you're
A
saying that.
judge may
okay,
not
okay,
disagree.
You're saying that if Mr. Beam had recused himself because of an appearance of conflict of the class one membership, then I would agree with you, but that's not why he recused himself. He recused himself because of his personal employment personally.
But let's switch it around. If the mayor had recused himself because of his employment, and then Mr. Beam was going to be the designee and his replacement, he wouldn't be allowed to do so. It's with respect to the position of class one.
Okay, you've at least explained your argument.
You don't,
Okay, you've explained your argument. Now I understand your
but
argument.
going back to it, okay? If the mayor does step in, and tries to listen to the tape.
I have the certification. The mayor has signed the certification. Let me do these right now. We have two board members. We have new board member, Mr. Ritt. That's Mr. Ritt. He is certified. He either read transcripts or listened to tape recordings of the hearings held on March 13, April 10, May 8, and June 12. And he's eligible to vote.
Can I,
And he signed it with today's date. And Mr. Barsany also signed with today's date that he has also either read the transcripts or listened to the tape recordings of the hearings held on March 13, April 10, May 8, and June 12. And so he's eligible to vote on the matter, and he's also signed his certification with today's date.
and let me just ask, are there actual written transcripts of those hearings, and are there recordings other than what's on YouTube?
I brought a court reporter to each of the hearings,
And were there transcripts generated
some.
and provided?
They weren't provided to the board. I personally got copies from Mr. Lapari, and I sent them to Mr. Beam to read.
Okay.
Mr. Ritt,
Mr. Barsany.
I'm sorry, Mr. Barsany. Oh, that's a Freudian slip. And Mr. Ritt watched the YouTube videos.
Okay, and with respect to the YouTube videos, I tried to watch the YouTube videos in preparation for this evening. You can't hear anything.
Mr. Ritt, you know what I'll do for you? I'll also send you the transcripts. I'm gonna
That,
ask you to read that.
I'm raising it as a procedural issue and not holding anything back.
Yep.
Okay?
Yep.
And lastly, if we're starting over, I think that there needs to be new notice of hearing. I put that in my August 12th correspondence. And the reason for that is that members of the public who were here at the last meeting knew that Mr. Simon was going to continue his cross.
I would think that everyone would come out to hear that.
You would think that if the driveway wasn't relocated since then in 40 feet closer to a different property owner, that those property owners may have been interested in it more and may have been more inclined to come out.
That's a different argument. You're arguing that the plan changes they made are substantial and that would require notice. That's a different argument.
And if the proceedings are tainted and it's a do-over in terms of that, and if there's a concern about that, there should be new notice appearing to recommence the proceedings. That's all I have to say.
Can I just quickly?
Say one more thing and then I'm gonna give Mr. Lepari the
Yeah.
ability
I'm not
to
trying
respond to
to-
everything.
Right, of course. I just wanted to just
I just
clarify.
wanna get, if any, you guys, I don't want you guys holding back anything. Put it all out on the table. I want Mr. Lepari to hear it. I want him to put anything else he wants out on the table, because when I take the board into closed session, I wanna be able to intelligently discuss the issues with them, and then we'll see what Mr. Lepari is gonna say after he meets with his client.
Yeah, I just wanna bring fully around this issue about the notice. Because I did submit a letter to the board earlier today.
By the way, just for the record,
Yes.
all the letters from all the attorneys have been distributed to all the board members.
Okay,
And
and
your letter of August 14th was placed at their chairs tonight.
okay, right, so and
You'll
I
get that in
I'm
the-
guessing
You'll get
that,
an email to all you guys tomorrow.
right, so I'm guessing that none of those letters, whether it's Mr. Lepari's letter, Mr. Groomer's letter, my letter, your letter, they don't have to be separately marked.
Correct.
Okay, so just with regard to, my letter, I did raise an issue with regard to notice, and I don't think, Mr. Drill, you want me to get into
The
the
details of that.
issue about the 10 days, and we'll get into that, I guess, after you emerge from closed session, et cetera.
No,
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 okay,
put it out there.
okay. That in terms of, when we talk about notice, that when you have a hearing and an applicant doesn't, regularly, constantly send 200-foot notices and publish in the paper every single time there's a hearing.
This, for members of the public. If you're taking a land use course in law school, this would be on the final exam.
Been there, done that.
Go ahead.
So you are permitted, ladies and gentlemen, under municipal land use law and some related case law, that at the end of a particular hearing, if the hearing needs to continue to a future date, that an announcement can be made.
To a date certain.
To, just about. So that an announcement can be made typically by the chairman or a board professional stating that the matter has been carried, or continued to a date certain, at a date, time, and place specifically, and that no further notice is required by the applicant. That means no further publication notice and no further 200-foot notice. And I tell my boards, it's a significant advantage and benefit to an applicant because they don't have to spend the money, time, and energy to go through that renotice process.
That's what I stated at the end of the July 10th hearing session, that it would be continued to tonight without need for further notice.
Right, so, but the flip side of that, as I explained, is that it's important, the reason why it's important to do it and important to do it accurately and clearly is that that's the only notice that the public gets. And what that notice is that the matter is being continued. It's going to continue where we left off at the prior hearing. So the public knows, okay, Mr. Seckler's in the middle of cross-examination, and that's where we're picking up. If it is determined that the matter is to start anew, maybe with the caveats that I'm recommending or implying, that you should not be doing it certainly tonight, because the public was not informed, I'm sure, of any of this, let alone being able to, okay, I realize now that they're gonna start over again. The public had no idea that it was possible even that they were gonna start over again, and that is why the matter should be, in fairness to the public, to be re-noticed. It's up to the board to determine whether that re-notice would be via a voice carry or whether republication is required. I leave that up to the board and the
Because
applicant.
what is your position on behalf of your client about the change in the plans where they shifted the driveway to eliminate a variance? Normally, the advice I give is if you need more relief, you gotta renotice. If your change is less, not more, and they've eliminated a variance from the township's driveway setback requirement that you don't have to notice, Mr. Gruenberg says that because they shifted the driveway, it's a substantial change and people in July 10th, were not aware that that was a possibility. What's your position on, does that have to be renoticed? Where normally my advice would be no, that does not have to be renoticed.
So normally, if you are an applicant and you come back and you say, yeah, I have 7 variances, and now I've eliminated 2 variances, I'm down to 5 variances. That typically does not constitute a quote unquote new application under section, I think it's 46, give or
It is.
take.
Section
Wow,
46.
that's not bad. Of the municipal land use law.
Yep.
Okay? I concur with you on that. However, what I am unclear about, because you're asking me, I'm just
I'm
gonna be
asking you,
flat
that's
out
right.
honest.
Yeah.
I am unclear as to the result of the relocation of the driveway, because originally, if I recall correctly, that the driveway in the original location was needed because the applicant or the applicant's professional testified that it was not possible to relocate the driveway because of some existing, I don't remember if it was a wall, a culvert, a stream,
Whatever,
something.
right.
Okay, now, I don't know if relocating that driveway that Mr. Gruenberg raised will lead to other things that may implicate new stormwater I don't know.
I
So,
understand.
so the
So-
quick answer is,
Yeah.
I'm not in a position today,
To take a
admittedly, to make an opinion on that. Okay.
That's similar to Mr. Lapari's, what he told us about making a decision on whether to restart or continue, or continue with the hearing, but okay. Mr. Lapari, you want to
Yeah,
respond?
and by the way, do you want me to talk about the 10 days? thing
Yeah, I
or
want
no?
you to talk about that too.
Okay, so, if we are, and Mr. Lapari is well aware of this. As the board recalls, as the public recalls, at the end of the last hearing on July 10th, there was a discussion about providing revised plans, information responsive to questions of the board professionals, some members of the public.
Site distance exhibits, the ITE.
All of that. And normally this board requires that all that be submitted 21 days prior to the hearing. And then everyone has a chance to.
And
a
the
fair
board
chance to look at it.
waived that.
The board waived it. And part of that waiver was in consideration of myself and Mr. Gruenberg asking, hey, look, when you if you're gonna send any revised anything, send us a copy so we get it at
And
least
Mr.
10 days
Lapari
prior.
agreed that you would get, when they submitted that stuff to the board, they would submit it to you and Mr. Gruenberg.
Correct, and that didn't happen, for whatever reason,
Okay.
okay? And so we first got it from Mr. Seckler directly. I think 2 days ago,
But-
although I understand that some of that material was on the
All of that
website,
material was posted to the website.
okay? I did not know, and first of all, I assumed that the matter frankly wasn't even going forward because I hadn't gotten anything. Or they weren't gonna revise their plan.
Mr. Drill, tell them what happens when you assume, Mr. Drill. Come on, I
Yeah.
know you're looking, I know you want to.
You're right, I do want to, but I'm not going to.
Okay.
But you saw it in my face, didn't you?
Saw it.
Well, but Mr. LaParry is making a comment as if no harm, no foul, okay?
But you're saying there's a foul here.
Well, there's.
You didn't have enough time to prepare?
There's definitely a foul, okay? So
just putting that on the record.
Okay.
Thank you.
Mr. Lepari, before you talk to your client and I talk to my clients, what else you want to say in response to what they said or anything else on your mind?
There was a lot there from both of them.
Yeah.
As far as the notice, I agree with you, and I think Mr. Simon wanted to agree that the change in the location of the driveway doesn't trigger the need for a new notice.
I think what he said is, at this point, he doesn't know, so that's,
Yeah.
that can down the road, depending on what happens with that, if, let's say you had to move a culvert or you need some other approval or whatever, maybe you'll argue that later, but at
What-
least for tonight, you didn't hear him say, yeah, you had to renotice because of that. I agree with that.
Yeah, most likely, when you put a notice in the application, you don't identify the distance of your driveway from an intersection of the nearest residence. You just,
If you need a
Identify the
variance, you do,
variances.
but if you have it in a
Correct.
compliant location, you don't. That's what we're saying, right?
correct. So there would, I don't see that as an issue, but I'm sure I'll get there at some point. As far as the 10 days, I did agree to it. I apologize. I was out of the country during that 10-day period. My engineer submitted it. I didn't give him the specific instruction to send it to everyone. I am aware that it was posted on the website. My paralegal checked it out. It's 10 days prior. That was an oversight. Mr. Simon could have called me. He didn't.
You would have been out of the country. You wouldn't have gotten to call back.
You might have got my paralegal. She's pretty good. She does a good job. But that was just an oversight because I wasn't available. I don't think there's any foul. He has much notice as the public and as much notice as the municipal land use requires.
I didn't say, for the record, I didn't say it was intentional.
I didn't, I know. I'm just saying, I don't really, it was an oversight on my end because I wasn't available.
We got it.
I
Anything
don't think
else?
that's a big deal. No, only that I'll speak to my client about the issues we discussed, but
Right.
it was even becoming more apparent that the issues are going to be raised one way or another by by the objector attorneys, if they choose to do it, if they choose to do it.
That's why I suggested that if you don't decide one way or the other, my gut tells me that I should be, but I'm gonna do it in closed session, that I should be advising them, but if this is preliminary, this is not my final advice, that to eliminate that claim from being made, not that I agree that it's tainted, but to eliminate that, the only way to eliminate that claim, unless you guys decide definitively what you're doing, is to restart it. But why don't we take a recess? You talk to your client, I'll talk to my client.
I will, but just a quick note is the best way to have handled this would have been to have disclosed the conflict or the appearance of conflict at the outset of the application, so that we wouldn't have had to wait 6 months and several $100,000 down the road to have this conversation tonight. That would have been the appropriate way to do it. And as a result, I'm now stuck to either handicap myself one way, tie my right hand behind my back or my left hand to continue. And that's what I'm stuck with as an applicant.
But you don't buy Mr. Simon's argument that started from scratch is not really started from scratch. It's like, it's missing, it would be missing tonight's hearing, but if you started up from scratch, we mean all new testimony. But
That's correct.
But the plans have evolved to the point that what took 4 months to put in, and I'm not disparaging you or your experts, but maybe because the thing wasn't as well thought out, or you didn't know what objections would be raised. Now you got a much better plan. And I don't want to prejudice the board. I'm not for or against the application, but the plan is much better after getting that input. It might not be, losing 4 months. It might be losing 1 month. That's basically his argument. I put it into numbers.
Not to keep going back and forth on this part of it, but to be honest with you, Mr. Drill, I believe that the affirmative testimony of this applicant was probably the least amount of time taken up as far as the entire proceedings are concerned. There's been so much discussion from the applicants, the members of the public, and the members of the board and their professionals that are just going to ask the same
No,
questions.
they're
and we have
not,
to start over.
because the plans now eliminate most of that stuff. But listen, take a recess. Now, the question is, do we have a room in this building that we can move to, so we don't have to move them out?
Unless we go to the firehouse.
Yeah, we want to the firehouse garage? All right, so let's have someone make a motion
How far do you have to go? So I know how much time we have.
through a door.
Okay.
Let's have someone make a motion, someone say so moved. Make the motion. To go into a closed session to get attorney-client privilege legal advice from me on all the issues you heard about where confidentiality is required for me to exercise my duties as a lawyer, so I can give you honest advice and not feel constrained that what I'm saying might be used against you. So, and because it's attorney-client, we're still on the record, people. Because it's attorney-client legal advice, the minutes from the closed session are not going to be disclosed to the public. And I'm gonna ask Gary Hill to then leave that area and come over here to join the closed session. Can someone make that motion? So moved. I'll second. Can you do a roll call on this?
Mr. Scuderi,
Yes.
Mr. Barsney, Mr. Chichillo,
Yes.
Ms. Cullen,
Yes.
Mr. Hill,
Yes.
Ms. Sherlock, Mr. Dodlow, Ms. Parker,
Yes.
Mr. Graham, Mr. Ritt.
Yes.
Let's, you declare a recess and let's, listen. He might only have 5 minutes, but I'm gonna need, I figure it's.
I've never seen any lawyer in 5 minutes.
Let's aim to come back at 8:30, but it might be a little later than that.